News Radio 700 WLW.
We've been talking about this, Rock, and it sounds dumb, but it is basically Apple suing Apple.
It does.
Apple on Apple violence.
Right, and it's all over a logo. Of course, Apple already has the iconic logo with, the bite taken out of it, but now apparently one Apple is not good enough. They need another one.
So let's call in. We always love to get this guy involved in these kind of discussions. He is the patent professor. He's our good friend, John Rizvi. And, John, break this down for us because we're having a hard time figuring out what the hell is happening here.
Yeah, so, a company's locked in a legal battle, Apple, with the Swiss government and farmers over an actual fruit. That's what it comes down to. Apple is seeking a trademark for an artistic rendering of an apple, which is not, as you said, it's not their logo. They're not looking for the bite out of the apple. They want the apple itself and want to have exclusive rights to that.
So my understanding is it's like a 111-year-old farmers organization called Fruit Union Sus or whatever. They're using the apple as their emblem. Like, why is Apple, a multi-billion-dollar company, picking on some farmers organization? What's going on?
Yeah, so part of it is as an intellectual property attorney, I'm looking at this and I'm thinking, they didn't file in the United States, and I'm wondering why. And I think they're simply trying to get a bunch of wins throughout the world. And then have some precedent to try to argue for protection in the United States. They've already succeeded in Armenia, Australia, Israel, Japan, Turkey, and now, they haven't won in Switzerland. They're appealing because I think the Swiss trademark office has rightfully said, listen, apples have been around for thousands and thousands of years before your company came along and decided to make its logo of an apple.
I feel like, you tell me if I'm wrong, John, but I feel like this is going to backfire for Apple because people are going to start saying, wait a minute. Again, like I said, this is a huge multi-billion-dollar company. And what is this all about? It just seems like for a company that always wants to be, hey, we're diverse and we're open, and we care about the little guy and all that sort of thing. Now they're going to try to claim an apple as their own intellectual property. That seems like it would backfire from a business standpoint.
Yeah, well, it's certainly in the court of public opinion, it's not making them look good at all. It almost reminds me of, for when Mariah Carey was trying to get exclusive rights to the Queen of Christmas, right? There's a huge backlash, and I think this is going to be the same thing. This goes completely against Apple's marketing of the uniqueness of an individual, and it clearly looks like a big bully just pushing their trademark. And in fact, they have filed 215 trademark oppositions to defend their logo. A trademark opposition is kind of legal proceeding where they think somebody else's trademark is too close to theirs, and some of their oppositions are just absurd. They've opposed a blog known as Big Apple Curry, which is a food blog in New York. The Big Apple has been around longer than Apple, so they've opposed a trademark for a company called Prepare, which is a meal prep company, because the leaf on their pear, notice I said pear, not apple, the leaf on their pear looks too confusingly similar to the leaf on the Apple logo.
God, it just seems like bullying to me. I just can't understand why that's a good thing. I mean, the risk versus reward there. Okay, so some other company, again, these are smart people, so I know there's a reason that they feel justified in doing it, but it just seems petty.
Well, here's the reason, and that is that most companies don't have the funds to fight back. So that company with the app Prepare, they just ended up changing their logo and picking something else. I believe Big Apple Curry, the food blog, changed its name as well. So they don't. Here's the worst part is they don't have to be in the legal right in order to win. They file these oppositions. It's time consuming. It's expensive. These small companies have to make payroll, right? They have to make rent and payroll and whatever. They have other expenses, and they decide, you know what, we're gonna just change our name because it's easier. It's less. Right. It's in some cases just for survival. They have no choice because they need the money for other things. They can't they can't go up against Apple.
So, John, and we're talking to John Rizvi here, the patent professor. And, John, I know I read someplace along the way, but how is there not a problem with Apple, the Beatles Apple? I get because that just doesn't exist anymore. So that was up for grabs because that was well established back in the 60s.
Yeah, so that case, I mean, so they've settled that, but of course it's been settled 3-4 times in the past, and every time it seems to crop up again as technology changes. So as Apple has agreed not to enter the physical CD and record industry, and now how music is distributed changes, so then it rears its head again. Currently that dispute settled. It's not, nothing's happening with it. I don't know for how long.
Is there anything else out there bubbling patent-wise we need to keep an eye on? It's the United States of America. Is that name safe, sir?
No. that should be fine. Again, this is just strange. I mean, I had a professor in law school that said that the exams come from real life because the stuff he can make up can never be as odd as the stuff that happens in real life. This I can't even, I just couldn't have even predicted that. That going after this farm collective and trying to get protection for an Apple itself, that's strange. If I had to predict, I don't think their appeal is going to do well, but I'm surprised they've succeeded in these other countries. So I think they're smart not to try in the United States because I don't think that they're going to be, have any success here.
With that, John, always a pleasure, sir. Thank you so much.